Senator Durbin.
Judge Wolf, I've been surprised, in a way, at the reaction of my Republican counterparts to this issue. Just last year, there was a bipartisan effort by two members of this committee, one Democrat, one Republican, to establish the standard of disclosure when it came to stock ownership by federal judges when they had before them a case that might involve that same stock or company. And it struck me that there was a true bipartisan spirit, that this was a reasonable ethical standard and should be submitted for the judiciary to live by that standard. Yet when we had a hearing about 3 weeks ago on issues related to Justice Clarence Thomas and his disclosure standards, it really broke on party lines, and the same thing has happened today, which comes as a disappointment to me as much as a surprise. This notion that anyone in public office at a level of senator or Supreme Court justice can receive hundreds of thousands of dollars worth of gifts in travel and hospitality and not disclose it and argue that, well, that was inadvertent, is to ignore the obvious. The American public takes a look at that and said, what is this judge doing? How can we trust his judgment if one Texas billionaire has such a large part of his life in terms of his attention? What's your response to that?
Essentially, what I think you've characterized accurately based on what I hear, just being a citizen, may be the reaction of the man in the street. However, as I wrote in my testimony, I think the Ethics in Government Act emerged after the Watergate scandal for good reasons. Greater transparency of financial activities of public officials, not just judges, was understood to be very important to assuring, among other things, the impartiality of judges. And I think that act struck, as it's written, a very appropriate balance. It gives the Judicial Conference the opportunity and the obligation to determine whether there's reasonable cause to believe there's been a willful violation. It doesn't permit them, the Judicial Conference, to make the ultimate determination of whether there was. If the Judicial Conference makes a referral to the Justice Department, it should diminish the potential and the perception that the Justice Department has launched a witch hunt against judge or justice. But the members of the Judicial Conference are not all impartial. There are friendships, there are professional relationships, there are interests.
That goes to the heart of the issue before us, and that is the fact that the Supreme Court of the United States of America has not established code of conduct and ethical standards that in and of themselves are trustworthy. And when this matter came before this committee several weeks ago, there were dissenters on the other side, on the Republican side, as to whether or not this was even worthy of talking of. They accused us of smear and harassment to even raise the facts brought up by ProPublica. And I also want to say their second argument we've just addressed here, and that's separation of powers. Do we have any business as Congress when it comes to the ethics of the court? Well, I thought that we did until we received a response from Chief Justice Roberts, and let me read it to you. This response was from the 2011 year-end report on the federal judiciary. Chief Justice Roberts wrote, "In addition to establishing judicial conference, Congress has enacted legislation addressing a number of specific ethical matters. In particular, Congress has directed justice and judges to comply with both financial reporting requirements and limitations on the receipt of gifts and outside earned income." Then he says, "The court has never addressed whether Congress may impose these requirements on the Supreme Court. The justices nevertheless comply with these provisions. In other words, I think he's going to the heart of the question as to whether anyone can raise a question about the ethical standards or establish ethical standards, even those embraced by the rest of the federal government. That, to me, gets to the heart of why we need to enact legislation, Senator. White House has a bill on the subject, others do, and I'm sure this committee is going to address it. This is not a witch hunt. This is not a smear. This is not a harassment. This is to try to rescue the reputation of the court from some very sordid facts that have been disclosed and proven.
And as you know, because you read it, beginning on page 4 of my testimony, written testimony, I considered not just whether it was encouraged that I come, but whether I come and testify today would be inconsistent with the independence of the judiciary or separation of powers. Again, emerging from President Nixon's administration is Supreme Court jurisprudence that says, sensibly, the three branches are not each in a silo. We've divided power so there'll be checks and balances. And if Congress is taking action that doesn't impact the performance of the court's core function, that's not a separation of powers violation. In fact, the D.C. Circuit case decided that in a case in 1994 concerning Congressman Rose. No separation of powers problem. And the core function of the courts is to decide cases impartially. Independence can be helpful to that, but independence is not an end in itself. An independent judge or an independent judiciary could be a dishonest judge or a dishonest judiciary. And therefore, a delicate balance has to be struck between the interests of independence in assuring that judges, like every public official and every citizen in the country, is somehow accountable. And the financial disclosure statute that you enacted and the Judicial Conference has a responsibility to properly implement is an important and appropriate element of that accountability.
Senator Hirono.